Good afternoon, and thank you for joining us for today's episode of Legal Learning. In today's episode, we'll be talking about association payments and foreclosure risks, an important issue for many homeowners. Today's presenters from the senior unit are attorneys Chelsea and Denisa, joined by paralegal Rick. With that, I'll hand it over to you, Chelsea.
Hi, we are Coast to Coast Legal Aid, and this is Understanding Association Payment Application and Foreclosure Risks in Florida specifically. So, disclaimer, this is not intended to give any specific legal advice. The information is current as of today. This PowerPoint cannot be reproduced, distributed, copied, or cited without our consent. And for more information, you can visit our website, which is there, or call our number, which is also on the screen. So today we're going to go over a few important topics that affect homeowners here in Florida. To start, we can think about some common questions and a lot of things that we see our clients come to us with. So, have you fallen behind on your association payments? Or have you made partial payments instead of paying the full balance? Have you received late notices from your association, or worse, from attorneys threatening to put a lien on your property? If any of these sound familiar, you are not alone, and we're going to walk you through what these situations mean and how you can navigate through them. Okay, so two different things, HOA and COA. HOA is Homeowners Association, and COA is Condominium Owners Association. What's the difference? There are honestly a lot of similarities, and we can touch on some of the key differences later, but basically, if you have an HOA, then you own the lot and your home on it. The rules for homeowners associations are at Florida Statute Chapter 720. And then if you want to look up specific things about assessments specifically, you can go to 720-3085. And then for Condominium Owners Association, you own your unit and you share ownership of building and common areas with everyone else who lives there with you. For that, you would go to chapter 718, and then if you want to look at assessments specifically, you'd go to 718.116. Okay, so this is where it gets a little bit tricky, and a lot of people struggle with the differences. You know, you make payments towards one thing, but you're not making payments towards another. So we'll kind of try and break down the different types of fees that you might be charged. And this is both for condo and HOA. So first, we have association dues, which are the most common. They cover the everyday expenses to maintain the property based on whatever your association's budget is. Think of things like landscaping, security, pool maintenance, any of those ongoing costs that occur monthly to keep everything running smoothly. Then you have special assessments. This is a one-time fee applied to all owners when something unexpected happens. So let's say there's a hurricane, or something happens and there's a big flood or anything like that, or the roof of the building needs to get repaired. This is going to be something that's unexpected and wasn't in the initial budget. So that's going to be charged to you specifically, along with everyone else who lives there. And then also there's fines. So let's say a specific unit owner violates one of the rules of your community. They'll get a specific fine, but that will only be charged to whoever is violating that rule. Okay, so bottom line when it comes to payments is on time, full payments equals a happy face. You're in the good, like you're doing good, everything's great. But where a lot of people sometimes end up is they make a late payment or they're making partial payments. You know, you aren't able to make the full payment 1 month, and that turns into a sad face. Because even though you're making this payment, sometimes the way that the payment is applied, you're still getting into a cycle of falling behind. So I think Denise and Rick are going to talk a little bit more about it later on, but I'm going to kind of just go through and tell you how the payments are applied. So first, when you make that payment, it's going towards the interest that's accrued on the balance that you owe. Then it'll go to any late fees that you might owe. Then if the association has to take any steps to collect on this debt, then you're responsible for any costs and reasonable attorney's fees. And then finally, it gets applied to the actual balance that you owe. Okay, so then these are the types of notices that you will receive. We're going to go a lot more in depth for each one, but here's just a general overview. So first, you'll get a notice of late assessment. This is basically telling you that your payment is overdue. Then you'll get a notice of their intent to record a claim of lien. You'll get a certain amount of time, which Denise and Rick will tell you about. But then the next thing that you'll get is the claim of lien actually being filed. In certain circumstances, if you dispute the lien, you can file a notice of contest. Then after that, you get a notice of their intent to foreclose on the lien. So once they have that lien filed, they wait a certain amount of time, they're able to actually foreclose on that lien. Then lastly is a notice of release, or sometimes it's called a satisfaction of lien. So after the debt is paid, then the lien can be removed. Understanding these notices is key because each one represents a step closer to foreclosure if you don't resolve the issue at the forefront. And then Rick's going to kind of go into and explain from the first notice that you'll get. So he can take over.
The first notice is the notice of late assessment. Why this notice is so important is because the law says that the association has to go ahead and send you a 30-day notice saying, hey, you owe us money and you need to pay it within 30 days. This is really one of the most important notices because if you don't realize you're behind or you have any questions, now is the time to deal with it within the 30 days after you get the notice. The reason why it's so important is because it could just be a simple misunderstanding about why you owe money, or it could be an association mistake, but whatever, you want to try and resolve it within this 30-day period. Reason being is because you're just dealing with the association and you are not incurring legal fees. That means it has not been turned over to a law office. Once it's turned over to a law office after the 30 days, every time you speak to the law office, or you write them, or you send them an email, they are going to be charging you more fees to go ahead and answer your questions and resolve issues. And at the end of the day, this is going to be added on to the amount of money that you owe to the association. These fees are very expensive. Just for writing you a letter saying that you owe money from the lawyer's office could be an additional $300 more that you are now liable for paying. So don't let it get to where the attorney writes you the letter. Try and resolve it within 30 days. I am done. Can't stress that enough.
Okay, and then you'll get another notice. So this is your second notice. It's the notice that they're basically going to, if you don't pay within now an additional 45 days, they're going to place a lien on your property. And so like Rick was just telling you, the first notice did not include attorney's fees, but this notice will include those attorney's fees. This letter will probably come from an attorney's office, and you have already started to begin to accrue those attorney's fees, which you will be responsible for. Again, you definitely want to take advantage of, making sure that you come current before this notice is due, because again, you are now accruing additional fees. So if you're making partial payments, like we said before, you are now going to pay these fees first before it's actually applied to your assessment. So again, just a reminder, as far as the application of payments, the law says that first it goes to your interest, then it goes to any late fees. And like I just said, it will go to attorney's fees for collecting, and then it gets applied to the delinquent assessment. So the claim of lien notice is basically letting you know that, hey, we actually have a lien on your property. Some of the things that will be in the lien are like your legal description. It'll have all of the property information, like your name, the association's name. It'll say how much you owe and how much you're behind. And it'll also be signed by the association, and basically verifying that you do owe that money and that they're going to place a lien on your property. There are statute of limitations for these recorded liens because they're recorded in the public records. And so generally, if a lawsuit is not filed, then the lien is void. And so for HOAs, the statute of limitation is 5 years, which means that they have to bring that lawsuit within that 5-year period, or the lien becomes void after that 5 years. And then for condominium associations, the statute of limitation is 1 year. And if you are going to actually pay the association in full, then at that point, that's when the lien will be removed from your property, and you will be receiving a satisfaction, which is also recorded in the public records to let the public know that you no longer have that lien, and that you have become current and you've paid all of the past due balance. There's a notice that you can do. This is not a notice that is by the association or their attorney. It's something that you can do. You can actually contest the lien if you're somehow disputing the lien itself. You're maybe saying that the lien is somehow invalid. It's generally not recommended unless the lien is very clear that it's invalid. So maybe your association did not follow some sort of rules that are in your declaration or your governing bylaws. They acted without certain authority, and they were passing assessments or passing fines for you that did not necessarily apply. And therefore, you want to contest the lien, you want to dispute it in some way. This notice basically says that you're demanding them to enforce their lien within 90 days. So you're speeding up that statute of limitations, which is why it's not necessarily recommended unless you know for sure that that lien is invalid. And if they don't bring their lawsuit within 90 days, then the lien is now void. So it's basically forcing them to stand behind the fact that they placed the lien on your property, and they have to actually bring the lawsuit to enforce their lien.
Before we jump to that one, let me just stress one thing about notice of contesting of lien. Very, very, very dangerous. It is highly suggested that you don't do it unless you consult with an attorney, and the attorney specifically says, yes, you should contest this lien. It's very dangerous to do that unless you're 100% going to be sure you are correct.
Absolutely. You'll receive a third notice from the association or their attorney's office, and it's the notice of delinquent assessment or their intent to foreclose. So basically, the association has decided that they want to foreclose because you're not bringing your account current, and they filed their lien based on your failure to pay, and therefore their association will file a foreclosure lawsuit no sooner than 45 days if you do not pay the unpaid balance. So that means that you need to go ahead and bring your account current, because now you're going to be facing a foreclosure lawsuit in which you will be responsible for any fees that they're going to incur as a result of that lawsuit. So, these notices give you chance after chance, to try to bring bring your account current, so that way you don't have to face the foreclosure. So what you should do, or how to avoid the foreclosure, you want to make full payments. We understand that sometimes things, happen, life happens, but you definitely want to make full payments. If you cannot make full payments, you should get into a payment arrangement. That payment arrangement should be in writing. You want to try to go ahead and account for your arrears that you are behind, so that way when you make your payments going forward, you can make your full payment going forward, as well as a portion towards your arrears. You can also consider bankruptcy if you have other debt, especially, and that way you can again count for the arrears that you have accrued so far. You can also consider selling if maybe you decide that the fees are just unaffordable for you. It's not financially feasible for you. You may want to go ahead and sell your property, especially if you have equity, because you don't want to risk losing your home to a foreclosure sale where you would probably lose out on your equity. So again, to avoid a foreclosure, you want to take notice of all of the notices you receive. You want to try to get into a payment arrangement at the first notice if possible. And you want to get into a written payment arrangement if you can't make, so that way you can bring your account current, or consider bankruptcy or selling. And at the very end, there's the release of lien, or the satisfaction, as most people call them. So once you make all of your payments and you account for all of your arrears and you bring your account current, then the lien will be removed. But it would only be removed once you have made full payment. And again, this notice will notify the public that the association no longer has a right to claim a lien for unpaid assessments against you, and you no longer have that lien and you are up to date. So these are just some of the areas that we offer here at Coast to Coast Legal Aid. We have a family law unit that handles, divorce, paternity. We have a victimless crime unit. We also have the senior and elder law unit to help senior citizens with various housing consumer issues. We have a mobile justice squad that comes out to people who are homebound. And then we also have a public benefits unit that helps with different public benefits as far as food stamps and Social Security. And then we also have a disaster response team for situations that, occur in Florida with our hurricanes. But as far as services, if you want more information, you can go to our website and you can apply for services for any of these areas. And there's our QR code and all our social media information, and our phone number is also listed there as well.
We're glad you joined us for today's episode. Understanding legal issues like this can make a real difference, helping you avoid problems and feel more prepared if they come up. Thanks for watching, and stay tuned for future episodes of Legal Learning.